This short video is for those of you assigned to the Ames brief Hark topic, Rule 33, motion for new trial on newly discovered evidence. I have made a handout available to you. It's on lawschool.thomsonreuters.com, a twin course called Westlaw Resources, Harvard Ames Brief. Lots of information available to you there. I can't possibly cover everything you're going to need to research for this issue, but the handout does go into detail, particularly some keyword searches using a relevance ranked and terms and connectors approach. I am available through several live classes I will be offering where we'll cover these particular searches as well as one-on-one, so feel free to reach out to me. For today, what I wanted to do was really focus on cases that were presented to you in the assigning memo. I mean, that's usually a good starting point if they give you cases and statutes. And what I simply did here was I just strung together 3 cases that were mentioned in the assigning memo. Keep in mind that when you find your cases and statutes, you're definitely going to want to save them to a folder. You're going to want to create a new folder. I'll end the session on some benefits of saving items to folders, but right now I wanted to focus on US v. Hinkson, which again, known document that we were given. Oftentimes you can collect a good 60 to 80% of what you need from those known documents if you know where to look. When you retrieve cases on Westlaw, you already know this, but always start by reading the synopsis and the headnotes. The synopsis, as you know, is simply a summary of the facts, issue, and holding in the decision. Headnotes are going to provide you with a summary of each and every issue in the case. This particular case has 16 headnotes, 16 different issues. As I scroll through, I can not only get a Cliff Notes summary of the case written by an attorney editor, but the headnotes also let me focus on the parts of the case that are most relevant for me. For example, if you look at headnote number 7, this really speaks to the standard or the elements that they're going to use in the Ninth Circuit on whether they will grant a motion for new trial. Headnotes serve 3 purposes. Number 1, they're going to provide us with a summary of each issue in the case. Number 2, every headnote that you see has been placed somewhere in the West topic and key number system. That, as you know, is simply a gigantic index of all American case law, arranged by topic. There are currently close to 500 main topics and subtopic. There are currently over 100,000 subtopics. Third thing that a headnote does for us, with one click, we can get every case that cited to, discussed, analyzed Hinkson for this specific point of law. We're going to get to that momentarily, but the thing I do want to point out right now, once you identify a good passage or headnote in a case, you might want to read and use the court's language. And a couple of tips here. Keep in mind on Westlaw, we do give you embedded key site flags throughout the decision. The other really nice thing that we do for you, you will never make the mistake of citing to the dissent or concurrence because we box the concurrence in blue, we box the dissent in red. That's why some of you may still have a running outline on the left-hand side of the screen. You really don't need it. If you want more real estate, you could collapse that outline because you're not going to make the mistake of mistakenly citing to the concurring or dissenting portion of an opinion now that you have that red and blue box available to you. Another tip, if you do want to use language, make sure you use copy with reference and set that to standard. That will give you a blue book not only copy the quotation, but it will provide it to you in Blue Book format. And the final thing that is new and actually pretty helpful, if you wanted to compare the language from two different cases to see, how they differed, you have an ability to add language up to 4,000 characters and compare it. And I did that already with a couple of other cases where it's showing the similarities and differences with respect to inducing entrapment. So that's something that will come in play, maybe not for Ames, but certainly something that you're going to be doing when you're researching down the line. Let's get back to that head note. This actually is head note number 7, one of the good issues from Hinkson that you're going to want to explore. That specific head note has been placed to the topic criminal law, subtopic Roman numeral 21, motions for new trial, subtopic under that, newly discovered evidence, and then you see in general. Why is that a mistake? And the answer is no. I mean, the law in this area has expanded, and they've made subtopics under the newly discovered evidence in general topic, and I'll show you what I mean by that in a minute. One click, as you know, gives me an ability to retrieve every case in the Ninth Circuit, and that's going to include Supreme Court cases classified to that specific point of law, newly discovered evidence in general, subtopic in general. Okay, so we got 112, but before we explore this in more detail, I do want to point out that you have a breadcrumb trail at the top here. If I click the subtopic newly discovered evidence in general, here are the other subtopics under that. So we just looked at in general, but you might also be interested in what constitutes newly discovered evidence and maybe some of the other subtopics under there, and you could quickly run topic and key number searches by clicking on those. But let's get back here to our search. These are going to be listed in reverse chronological order. If you want the leading case in the Ninth Circuit on this issue, make sure you sort by most cited. When you do that, you'll see that Kulzik has been cited 132 times for that particular issue. Johnson has been cited 103. There's Harrington, which you certainly are going to want to take a look at because that was the genesis of that Harrington standard. Another way of looking at this information, we could filter by jurisdiction. So if you wanted to knock out the U.S. District Court cases and only look at Court of Appeals and Supreme Court, could filter by date. I also can filter using keywords. And one of the things I might do here is see of these 112, how many of them mention, I don't know, affidavit. When I apply, I knock it down from 112 to 8. And these would certainly be 8 worth reading and maybe even selecting and adding to a folder. All right, at this point, I'm going to just go back using my history so I can look at Hinkson in that head note again, because as I said, head notes serve 3 purposes: summary of every issue in a case. 2, they let us know where that issue has been classified in the topic and key number system. And 3, Hinkson is important to you. I want to get every case that's cited to Hinkson, not in general, but just for this particular point of law. There are 51 such cases. And by the way, what I'm about to show you is just a quick shortcut to getting exactly what you need. You might have been taught citing references earlier. Citing references would give us an ability to get every document that ever cited to Hinkson. And eventually I could using the filters filtered down to only cases that cited to Hinkson for head note number 7. I mean, that is one of the filters you could have applied. But what I'm about to show you is something called key cite this head note, and it really is a much quicker way of getting exactly what you need. So, Hinkson being a really important case for us, I want to get every case that's cited to Hinkson for this specific point of law. When I click, Westlaw automatically applies the filter. I get the 51 cases I'm interested in, and now I can maybe cull this list a little bit more using my filters. I have that search within results feature where I could add a keyword. I could, again, limit by jurisdiction, and even, and this is one I want you to remember, depth of treatment. You're really generally going to be interested in 4-bar cases first, if there are any. 4 bars means that case has analyzed your case for at least one full printed page of text. 3-bar cases discuss your case for at least a paragraph, but less than a printed page of text. 2-bar cases analyze your case for about a paragraph. Don't waste time on 1-bar references because they don't analyze your case at all. They simply mention the citation, CEG US v. Hinkson. So, I could knock that list down to just 3 or 2-bar references. Another tip, your passwords in terms of level of detail are probably set to either less or more. Make sure this is set to most, because when you go through a list like this, it gives you a much more efficient way of identifying potentially relevant cases you want to follow up on. Okay, 2 final tips. I mentioned that folders are important. If you click folders, I'm going to just take a look at my Hark folder here. One of the things that you have the ability to do with folders is share a folder. If you click on the, if you want to call these 3 vertical dots or vertical hamburgers, you have an ability to share your folder with your colleagues. So if you're obviously teamed up with another classmate, you might want to share your research with them. But the thing I really wanted to point out that's going to be very helpful with respect to folders is something called folder analysis. When you add items to a folder, Westlaw is analyzing the items in the folder, looking for common issues. And it's a way for you to confirm that you haven't missed anything and that your research is complete. So you will always want to take a look at folder analysis because it will potentially suggest additional highly relevant cases, statutes, and secondary sources. The other thing that is going to be really helpful, once you have completed the draft of your Ames brief, as well as the final version, before you submit the draft, before you submit the final version, make sure you run the documents through Quick Check. Quick Check is a safety net. It makes sure that you haven't missed anything. So when I click on it and I click check your work, what it will do is go through your brief. It will recommend, based on the arguments you've made in the cases and statutes you've used, it will recommend additional potentially highly relevant authority that you didn't use. It's going to also warn you of any cases, statutes, and regulations that have negative authority. And in particular, the ones you really want to be on the lookout for are the red flags and the orange overruled risk markers. And finally, it has a quote checker. It will check your quote with the quotes with the actual quote on Westlaw and let you know of any differences. And the other thing that's really nice, it has an ability to alert you to any pin cite errors you've made in quotes. That is, if you cited to the wrong page of a case when you used a quote. All right, as I said, I don't have time to get into the actual keyword searches that you would be running. That's something we could talk about in a follow up live session or a one on one session, or you could just pull up the handout yourself. I've provided hyperlinks. You could click and run those searches on your own. If you have any questions, let me know. Thank you for your time and good luck.